Hi, everyone, and welcome to a PowerPoint presentation on how a trial proceeds. This is, again, part of week 3 of the semester, where we are learning about court systems and also how disputes are resolved. So we know that in the United States, our legal system is used to resolve disputes between parties, and we know that that involves the courts. So we already talked about the court systems themselves and the hierarchies and how we start with a trial court and then we move through the procedures to those higher courts, the appellate courts. But in this PowerPoint, I wanted to take a step back and actually talk about how the trial proceeds. This section is actually laid out very well in your book, but I wanted to bring you some of the key highlights for how a civil trial proceeds. And again, I want to remind you that we're talking about a civil trial here, not a criminal trial. Although a criminal trial does have similar proceedings to a civil trial, the focus here in business law is, of course, on a civil trial. So remember, I just wanted to remind ourselves of these slides here that we're talking about the federal court system and the state court system. And you can see that I'm just, in case it's been a couple of days since you watched the PowerPoint, the court systems, I thought I'd remind you of them here. And remember that the trial court is that lowest level court, and it, of course, is where the trial takes place. So what we're going to focus on in this PowerPoint all takes place at that low level trial court. So the focus now is on the civil trial system and how a civil trial proceeds, how that court case proceeds. We will not focus here on the appellate practice, what happens when one party loses. So if we're talking about Massachusetts, we're talking about the Superior Court or the district court in the state. If we're talking about a federal case, we're talking about the U.S. District Court. So that's just a little bit of background reminder. So every case begins with a story between real people and real individuals. We see that in the case that I have you discuss in this unit on the Kuhn versus PubZone case, right? That's a case that involved a real individual who went to a bar and was beaten up there. But we can talk about any type of dispute that individuals might have. Maybe you're a house painter and someone hires you to paint the exterior of their house and you do it and then they don't pay you. Wouldn't you like to sue them? That would be an example of a civil trial, and it would involve real people, real individuals, you, the house painter, and the homeowner. The same thing would be true if I went to Market Basket and I'm just doing my shopping. I'm a real regular person. Professor Sugarman, when she's not teaching, is a real person who goes to the grocery store. So I go to the grocery store and I slip and fall on a banana peel and I want to sue Market Basket for my injuries. Again, every single trial begins with real people, real individuals, and real problems. And we call the person in a civil case who's been injured, who's been harmed somehow, we call that person the plaintiff. Plaintiff is a term that is only used for civil cases. You can remember that from earlier on this semester. When we talk about a criminal case, do you remember who brings that case? It's the state, the attorney general, or the district attorney. So if we see the word plaintiff, we know we're talking about a civil case. And again, the civil case plaintiff is someone who's been injured. Now, the injury could be a physical injury, even in a civil case, like my slip and fall at the grocery store. Maybe I break my ankle and I have medical bills. Maybe I have medicines I need to take and doctors I owe money to. What if I missed time from work, right? So my injuries could be both physical injuries and they could be financial injuries. And then the plaintiff sues the defendant. So we talk about parties to a case. Now, we don't mean parties like get a bunch of balloons and put out a bunch of favors for everybody. What we mean are the entities, the people that are behind the lawsuit. A civil plaintiff and a civil defendant could be an individual, like just me, myself, one person, like if I slipped at Market Basket. It could be a business, like suing Market Basket. It could even be the government. The government could be a party in a civil case. For example, if I injured myself on state property, maybe I sue the state or I sue the federal government. So the case proceeds by the plaintiff starting the lawsuit. I'm going to go over some of these procedures a little bit quickly. I don't need you to know all the details, but I do want you to understand how a case proceeds. The civil plaintiff begins her case by filing something called a complaint. A complaint is a document written out on paper, of course typed, and the complaint basically says, you defendant, you did something wrong. And the complaint is an opportunity for the plaintiff to tell her side of the story. Here's what happened to me. Here's why you, defendant, did something wrong. You didn't pay me for work that was done. You discriminated against me. You fired me. You left a banana peel out on the ground that I slipped on. The complaint could say any of that. And then the complaint also gives the legal reason behind the lawsuit. That's actually a lot of what we're going to focus on later this semester are the reasons, the legal reasons that the plaintiff actually can bring her lawsuit. The defendant then drafts an answer, which is a document that basically says, no, I didn't do those things. The defendant doesn't really get to tell their side of the story. It's more like a denial. Like, you plaintiff said that I left a banana peel out and you slipped on it. And then Market Basket, the defendant would say, no, that's not true. That's how it proceeds. Then the parties, again, the plaintiff and the defendant, in a civil case, move to a stage called discovery. Discovery during civil litigation can take years. You may have heard that cases take a long time to resolve, and they do. It takes a long time to get to a trial, and discovery is the primary reason. That is because the civil cases, the parties have a right to learn all the information that the other side has. And discovery is the phase in which they do that. The plaintiff can ask the defendant for all the documents, all the information that the defendant has, and vice versa. And I want you to take a look at your book. Your book has a little bit more detail about how the parties do that. But basically, the court systems, the rules give the parties an opportunity to interview witnesses, take something called depositions, examine documents. You can even go, like if you're suing Market Basket for a slip and fall, you can ask them for, videotapes. You can ask Market Basket for their safety procedures. You can find out who was working that day. You can interview them. That's called taking a deposition. And all of this fact finding, this information gathering is actually really time consuming for attorneys representing the plaintiff and the defendant, just because it takes a long time to figure out what information you want from the other side, who has it, and how to get it. And so that's why it ends up taking potentially years to find out. And then you know how this goes. If you're investigating something, you find out one little piece of information and it leads to something else. So it's not like you could conduct this discovery phase in a couple of months. It takes a long time. But eventually, the parties get to the end of the discovery phase, 1-2 years later, and we start, I had one more slide about a discovery example. Forgot about that. Let's imagine a lawsuit where Sugarman, that's me, I sue Middlesex Community College. Let's say I assume they fired me because I'm a woman, and I think it's gender discrimination. Just pause the video here and take a read. I just wanted you to have an idea about what kind of information you think that I would want to learn as a plaintiff suing Middlesex Community College, and what kind of information Middlesex Community College might want from me. So just take a read. I won't read this slide to you, but I just wanted you to start thinking about why this takes so long to conduct discovery and how this case proceeds through the civil trial phase, all marching toward the trial. Okay, now at the end of discovery. At the end of discovery, the parties get ready for the actual trial. This is when the witnesses will testify. This is when the attorneys will get to show the jury social media posts, handbooks, pictures, videos, whatever of that evidence that they gathered during discovery. And I do want to mention that word here. I should have mentioned it on the earlier slide, but think about that discovery phase as gathering all the evidence that the plaintiff would use to prove her case, but also evidence the defendant would gather to establish that he or she or the company didn't do anything wrong. So just put that back there with the discovery thoughts. Right before a trial, parties can try to obtain summary judgment. Either party can move for summary judgment. This is a fancy way for the attorneys to argue that there's no basis for a trial because there's no disputes of fact, and the judge can decide the case is a matter of law. I don't want to talk too much about summary judgment. It's a very complicated legal proceeding, but it basically allows a case to end before a trial. Again, the case gets dismissed in one of the parties' favors. But if the case is not dismissed on summary judgment, the parties now move forward to the trial. I know my next slide has a lot of stuff on it, so just bear with me. The trial itself is the pinnacle. This is what the plaintiff has been moving toward. Now, a lot of plaintiffs really want their day in court, right? A plaintiff who feels that she's been harmed, fired from her job for discrimination, a contract claim where she wasn't paid for work to be done or work was done faulty, or a slip and fall situation. Plaintiffs want to be able to go to court and turn to that jury of their peers and say, here's what happened to me. And the jury trial is that opportunity. So think about all that evidence gathered during discovery. We have during the trial phase, remember, we're talking about the trial court. So how many judges? Just that one. And now we have a jury serving as the fact finders. The attorneys for each side give what's called opening statements, where they explain to the jury what will likely be, what they'll be hearing. You know, this is what this case is about, and you're going to hear from these witnesses. And both the plaintiff and the defendant have the opportunity to make opening statements. Then each party presents their case. Usually the plaintiff goes first. And how does the plaintiff present her case? It's not like the attorney just gets up there and says, once upon a time, the plaintiff went to Market Basket. No, the plaintiff presents her case through witnesses and through evidence. So all of that information gathering during discovery, if it's Market Basket, maybe the plaintiff wants to call the manager as a witness. Maybe the plaintiff wants to call another customer as a witness to say, yeah, I saw that banana peel on the floor and nobody was picking it up. And then the plaintiff will introduce evidence like video recordings or a safety manual. And after the plaintiff does that, the defendant will do the same. At the end of that evidence presenting phase to the jury, the plaintiff's attorney and the defendant's attorney will make closing arguments where they summarize to the jury everything that they have heard and make a case to decide the case for the plaintiff or the defendant. And this is really the last point I want to leave you with, is that in our civil trial system, there is a winner and a loser. There isn't a way to say, well, it's kind of in the middle. The jury will issue a verdict or a decision for either the plaintiff or the defendant. So this is really an adversarial system that we have, where throughout this whole process, we produce a winner and a loser. Now, remember, of course, the loser could appeal her case, but that's expensive and time consuming also. The reason I want to bring up this end to the process is I also want you to read about alternative dispute resolution. And I have 1/3 PowerPoint about that, because I want you to compare this civil trial system with alternative dispute resolution and try to decide which do you think is a better way to resolve disputes. So again, I know I went through this process really quickly. Feel free to re-listen to this PowerPoint and read the section in your book about the civil trial system. But I really just want to press upon you some of the stages that the case moves through, and also understanding that it is expensive and time consuming to get to that point. So make sure you read that section of the book, and then after, listen to the 3rd PowerPoint on ADR, or alternative dispute resolution, and then we can compare the two.